So please welcome Mark.
All right, well, thanks for having me. I was asked to talk about sham contracting and employment protections, I think prompted by the advent of operators such as Uber and Deliveroo and Fedora, I think are probably the main ones, who have, across the world really, been implementing new modes of engaging persons to perform work, which they see as providing opportunities for individuals to run their own businesses in the new technological app economy, or gig economy, as it's sometimes called. Sorry? I don't think it's an acronym, although I didn't invent the term. I think it's just so...
It's the acronym sector, so people just assume it's an acronym.
As I say, I think these businesses like to style themselves as allowing individuals to participate flexibly in running their own businesses. Coincidentally, or perhaps not, one of the byproducts of the mechanisms they're setting up is the erosion of traditional protections applying to employees and the avoidance of the entitlements and conditions which are ordinarily required to be applied to persons who are employed to work in a traditional employment relationship. And that gives rise to consideration of, well, what is the sham contracting? Perhaps it's a good place to start with a definition. Basically, a sham contract is understood as being a contract or a circumstance when an employer is deliberately disguises an employment relationship as an independent contractor arrangement instead of engaging the worker as an employee, the byproduct of which is, as I say, the avoidance of employee entitlements such as superannuation, workers' compensation, leave and other, even taxation obligations. Now, whilst the likes of Uber and, I mean, if you don't know, Deliveroo and Fedora, the people you see riding around on bikes with kind of insulated packs on their backs or on the back of the bikes, wearing some kind of uniform, and people presumably know what Uber is. Whilst they have some new forms of operation, particularly the way in which they engage with customers is through an iPhone app or a smartphone app, they present really what has been a long-running problem which the law has had in protecting or regulating employment relationships. And perhaps to understand that, it's necessary to start with a little bit of history. Really arising out of the Industrial Revolution, the parliaments recognised over time that employees required some kind of regulation by legislation in order to prevent rampant exploitation. That it was undesirable socially for employees to be left purely to their contractual rights, and some kind of legislation was necessary in order to prevent the excesses of a purely laissez-faire economy. And that, initially in the UK and adopted in Australia, resulted in the enactment of minimum conditions for employment. Initially, such fundamental things as restrictions on engagement of child labour, protections of health and safety in the workplace, and blossomed into the more complex regulations that we have had more recently of hours of work, minimum rates of pay, penalty rates, at least to some extent, that we, in some respects, still have today. Now, in Australia, that took a particular route, which was from the commencement of federation through a process of conciliation and arbitration, which resulted in the making of industrial awards setting minimum terms and conditions of employment for employees in relation to matters such as hours of work and rates of pay and matters of those natures. And we still have, albeit somewhat changed, that system today through, at a federal level, primarily what's the Fair Work Act, which establishes a system of modern awards setting minimum conditions. It contains minimum legislated standards of employment conditions, dealing with leave and other entitlements in what's called the National Employment Standards, and provides for the making of enterprise agreements, which can also be used to set minimum conditions of employment. The system, though, of employment protections has always been founded upon the idea that employees, dependent as they are upon their employer and subject as they are to the direction and control of their employer, require a special degree of protection to ensure that the rates that they're paid or the conditions that they are afforded are not substandard. The system of minimum employment entitlements has always worked on a distinction between employees who require that protection and persons who work in their own business as self-employed people who are, so the theory goes, able to negotiate sensibly and reasonably their own commercial conditions of engagement and compete in a market for customers or clients. The consequence of that is many of the rights and obligations that are established by industrial legislation are dependent upon the existence of an employment relationship rather than an independent contractor or self-employed business. And those include basically all of the fundamental minimum protections applying in employment relationships. Minimum wages, the national employment standards dealing with various leave entitlements, maximum hours of work, notice and redundancy pay, provisions, modern awards and enterprise agreement, superannuation guarantee, entitlements, workers' compensation entitlements, unfair dismissal rights and general protections claims, and the protections that are afforded by the principle of vicarious liability. Now, there is some complexity to some of those, so I don't want you to take them entirely literally. The Superannuation Guarantee legislation is expanded in some sense to apply to persons, even if not employees, who engage in work under a contract primarily for their labour, although that's been interpreted relatively narrowly. So there is some expansion, but substantially all of these rights are dependent upon the existence of an employment relationship rather than an independent contractor relationship. And the justification for that limitation is that people running their own business, independent contractors, are, as I've said, seen as able to negotiate appropriately their own contracts in a manner which enables them to have a degree of bargaining power in the relationship. It's of course it's not entirely new for businesses to see a benefit in endeavouring to characterise the workers that they need in order to run the business as contractors rather than as employees. The benefits of so doing are obvious. If all of these protections or entitlements are dependent upon the legal characterisation of the relationship under which the worker performs work, then self-evidently one can avoid those obligations if the business is able to successfully characterise the relationship in a legal sense it has with its workers as a contractor relationship, or successfully characterise its workers as self-employed people running their own businesses. And as I say, this is not entirely new, particularly since the 70s and 80s. The labour hire industry has been in a very concerted and deliberate attempt to characterise persons engaged through labour hire agencies in a range of occupations, from security work, delivery work, IT is very common, even administrative work, to characterise workers in those types of roles, if supplied through a labour hire agency at least, as contractors. The likes of Uber, Deliveroo and the like have attempted a new spin on this, perhaps, by utilising the image they have as technologically advanced to portray the way they operate their business as different or new to existing businesses. But they do, very deliberately, it is clear, endeavour to construct relationships with the drivers in Uber's case, or the cycle or other couriers in the food delivery cases, as contractor relationships, as self-employed people in order to avoid the entitlements that would otherwise flow. Now, I don't have any particular inside knowledge of these businesses, but their documents are pretty much available online, so it's not that hard. But one can get an Uber contract pretty easily. This is with a company called, I don't know, Razia, I'm not even how to say it, Pacific, which apparently is some kind of partnership in the Netherlands, which is the Uber entity which engages persons in Australia. And it's a long contract, obviously, but you'll see that there's a very clear attempt to assert that the parties agree that the agreement is not an employment agreement and does not create an employment relationship for any purpose, and also no joint venture or other relationship. So it's a very clear statement, and there's a myriad of other terms of the agreement which are directed at the same objective of characterising the driver who's delivering passengers from one place to another. That trip having been booked through the Uber's app, not as working for Uber at all, but as running their own transportation business. Deliveroo's similar. This is from a UK contract from in Australia. It has provisions which, again, overtly state that this is not an employment relationship. It goes even further and purports to constrain the cyclist from going to any tribunal or court to contend that they are, in fact, an employee or a worker. So they obviously see the dangers in going anywhere near a court with this arrangement. And again, I don't profess to have any particular inside knowledge of this, but it's clear that the workers, or to use a neutral term, that ride the bikes delivering food or drive their cars for Uber, don't get many of the things that employees generally get. They don't get, the payments are generally calculated per delivery or per trip. They don't get any minimum guaranteed hourly payment or any minimum guaranteed payment at all. They don't generally have any particular guarantee of the provision of work, so it's not guaranteed that the person will get a certain number of deliveries in a shift or indeed any at all. They will have very little security of engagement in the sense that really at any time they can be, the company can cease providing them with work to do, or without even really terminating the arrangement, but also terminating the contract if they at virtually no notice. Then they're generally required to provide their own equipment and maintain their own equipment and the like, pay their own tax, get insurance arrangements, are responsible if they injure themselves or other people in the course of their, or purportedly at least, responsible for the injuries to themselves or to others which are occasioned in the course of the work without the protections that employees would otherwise have were that to arise. Now, the law is to some degree alive to these the potential for evasion of minimum entitlements of minimum employment entitlements. The Fair Work Act does contain what are called sham contracting provisions now. They only came in when the Fair Work Act commenced in 2010, which purport to prohibit, or which do prohibit, a person, known as the employer, that employs or proposes to employ an individual from representing to the individual that the contract of employment under which they work is or would be a contract of services under which the worker performs work as an independent contractor. So if a worker engages a person as an employee, they will breach this provision if they tell the employee that in fact they're not an employee, they're a contractor performing work under a contract for services. You'll see there's a defence involving lack of knowledge or lack of recklessness. There are other provisions too. Section 358 prohibits an employer from sacking a worker and then engaging them as an independent contractor to do substantially the same work. And 359 prohibits an employer from making false statements to persuade or influence a person to become a contractor rather than an employee. Now, these provisions, whilst useful additions to the protections that the Act provides, essentially beg the question as to whether the person is engaged as an employee or a contractor. That is, the employer can only breach this provision if, in fact, or perhaps fact's the wrong word, if as a matter of law the person is an employee rather than an independent contractor. Now that question is a little bit more difficult to answer. The Act itself, or the legislation, hasn't attempted to define what an employee is and what a contractor is. One goes back to the common law or to the decisions of courts over many years in order to endeavour to answer that crucial question. And although, for the reasons that I've explained, it is a crucial question for the purposes of determining a whole raft of entitlements of employees, the law has struggled to arrive at a test which is easy to apply and produces a clear answer in at least a reasonable proportion of cases. Now look, most people will clearly be employees, or many people, will clearly be employees or clearly be engaged in their own business. Having said that, as I say, the lack of a really clear test means that there will be a significant proportion of uncertainty or a number of persons who fit within a grey area, which might be arguable one way or the other, and in relation to which one will only really know if one takes a matter to a court. Without attempting to embark on Employment Law 101, the way in which the courts have endeavoured to distinguish between an employer and an employee initially was concentrated on a question of control, so whether or not the employer controlled the manner in which the employee performed his or her work. So not just the task to be done, but if the employer controlled the manner in which the work was performed in a detailed way, then the person was an employee. If the worker was able to determine the way in which the work was performed, then the person was found to be a contractor. The situation has become a little more complex in that the approach now is generally what's called the multi-factor test, and the courts will look at a range of different factors. This is one of the High Court cases which dealt with it, so other matters that are in addition to control are mode of remuneration, provision of maintenance of equipment, obligation of work, hours of work, provision of holidays, deduction of tax, and delegation, etc. So some of the factors are these. So mode of remuneration, so employees are more likely to be paid by way of some regular salary or time-based payment of work. A contractor is more likely to be paid a lump sum to produce a particular result or to do a particular task. Employees generally won't provide their own equipment, at least of any value, whereas if you're running your own business, you might have bought an expensive piece of equipment in order to run it. Employees generally have to turn up to work when they're told to, according to some reasonable schedule, whereas a contractor is more likely to be able to say, when rung up to do a job, no, I'm busy today, I'm going to work for someone else, I can do it next Thursday or whatever the case may be. Again, dictating the place of hours of work. The deduction of income tax, provision of holidays and the like is a bit controversial because it becomes somewhat of a self-fulfilling prophecy in the sense that if the purpose of the whole arrangement is to avoid having to pay holidays or deduct income tax and the like, if that's one of the considerations taken into account, then not providing leave or other entitlements to a worker leads to the consequence that you don't have to provide those entitlements is somewhat of an irony. But it is a factor that the courts have considered. Rights to suspend or dismiss and delegation of work. Generally speaking, if you're employed as an employee, you can't get someone else to turn up for you. You have to do it personally, whereas a contractor might be able to delegate the work to another person. Now, all of these factors are matters that are just thrown into the mix, and things are put on one end of the scale or the other, and ultimately someone has to make a decision, which, as I say, in a number of cases will be far from certain as to which side is heavier, whether the employee side is heavier or the contractor side.
Mark, you again just talked about the weight that might be attached to one of these provisions over another, because obviously a lot of the people who present at our centres, pretty vulnerable, you know,
Yeah.
clearly they're being told what to do and where to be, but they might be told, yes, you've got to invoice, they might be told you've got to bring your own equipment and so forth. So probably moving into that sort of Uber argument in a way, that obligation or dictating, you know, being told where to be, that's most likely to be the one that's going to be the case for our clients, while the others might look fair and square like independent contractors, that there's such a level of control.
Look, one of the issues with the cases in this area is that this issue comes up in a whole different range of legal areas. That is, it comes up in cases about tax, about payroll tax or superannuation, or deduction of income tax. It comes up in cases about employment rights, wages, hours of work and the like. It comes up in tort cases about vicarious liability. So it comes up in all different areas of law, and it means that the cases aren't necessarily entirely consistent in the way in which they approach this question. I don't think you could say that any particular factor is of greater importance than any others. It really is just throwing everything into the mix and working out what is the, on an impressionistic judgment, what is the correct outcome. So I'll just give you a second. I think some of the, and I was going to come to a High Court case, one case in a moment, which is relevant in this area. I think some judges, at least, and I can't say this is all, but some courts will attach particular importance to whether, look, at the end of the day, in truth, is this person running their own business or not, in any reasonable sense. And some of these factors all play into that, of course. The obligation to work, provision and maintenance of equipment, the mode of remuneration might all play into. But can you really say that they're running their own business, or are they working for someone else? And that is, it's not a strict test, and some courts have sort of rebelled against that as kind of an overarching theory, but it is a reasonably good way of looking at it. Look, is in reality this person running their own business? Sorry, this.
All right. My question was around, so when you're looking at contracts generally, and obviously this arises in different contexts and courts, as you mentioned, but you're looking at contracts and you're looking at mutual agreement, what's the understanding? To what extent do the courts place greater weight on the fact that employment legislation is protected, you know, and to what extent are they going to give weight to any sort of mutual understanding? So they're going to arrive, essentially two parties mutually agreeing that the person is an independent contractor. Of course, the worker is often forced into that position, but nevertheless they're paying taxes as if they're a business. Have you seen courts that will just...
Yeah. Look, some decisions take... Well, the long and short of it is that if a contract says this is an independent contractor relationship and not an employment relationship, and look, labour hire contracts inevitably say that as the first line of the contract, and it's usually in capitals and underline it, but that is not determinative. The courts can say, no, well, that's what it says in the contract, but we're willing to look at the reality of what actually happened and what the true nature of the relationship is. Some decisions have said, though, that it's not irrelevant, in the sense that if this is a kind of borderline case, that the fact that the parties have agreed that the relationship has a particular characterisation, and other matters are agreed, such as the parties agreed that they're not entitled to leave and the like, which will be written into these contracts too, can have some relevance if it's a borderline case. I'd say that courts are not blind to the fact that these contracts will be written by one side and presented as a fait accompli to the other side. They're not negotiated in any rational sense at all. I mean, Uber is not negotiating these contracts with its drivers. It has a contract which its lawyers have dreamed up over many long hours of planning. It's not an accident, and that the driver's not in a position to say, well, I agree to it, but not this clause here. So the courts are not blind to the reality of that, I don't think.
I won't take up too much.
Yeah, you're right.
Is where a person asserts they're an employee, but they're actually paying business tax. That kind of complicates things.
So they have their own taxation
if
arrangements.
if they've got a company there and they're
Yes.
actually paying tax at the company rate rather than the individual rate.
Yes.
It sounds quite, I've had one particularly messy one where it was very difficult to
Yeah.
get an
Look,
employee field, even though it was really a sham person.
yeah. Look, obviously, individuals can get, and I mean, it really is, it can get to quite absurd degrees in some cases. As I say, IT is quite common in this. I had a case for this guy who worked for Centrelink, ostensibly, in the sense that in Canberra he went into a building which had Centrelink written over the top, and he worked there for 10 years, he was the only guy who knew how to work part of their IT systems. But he didn't work for the government or anything, and actually finding out who he worked for involved 4 or 5 different layers of companies between him and the entity. Now, if you've set up tax arrangements like that, it can lead to difficulties in that being unwound, as it were, and it's there can found to be a true employment relationship, even if in a legal sense there's been a company interposed, but that's an extra degree of difficulty, I think, in succeeding in such an argument. All right, the case I was just going to mention is about cycle couriers. I think that's in the UK, not Australia. It doesn't seem to. That would comply with health and safety regulations. But the case is a case called Hollis and Barbu, and I'll just read you the facts of the case very briefly. Barbu at all times conducted in the Sydney area and under the business name Crisis Couriers, a business delivering parcels and documents. You'll be familiar with it. On the 22nd of December 1994, Mr. Hollis was leaving a building in Ultimo where he had attended to pick up a parcel. He had taken 2 steps on the footpath when he was struck by a cyclist and knocked to the ground. The cyclist went over the handlebars and landed in front of Mr. Hollis. The cyclist stood up and said, "Sorry, mate," and left the scene, pushing his bicycle. He ignored Mr. Hollis's calls. The cyclist remains unidentified. So Mr. Hollis suffered injuries in this event, and looking for someone to sue. He couldn't sue the cyclist, obviously, because he didn't know who the cyclist was. But he did know who the... the cyclist remains unidentified. However, he was wearing a green jacket on the front and back of which, in gold lettering, there appeared the words Crisis Couriers. So he didn't know who the cyclist was, but he didn't know who the cyclist was working for, in some sense. However, and that was a company called Varbu, which operated Crisis Couriers. However, Varbu was only liable for the negligence of its cycle courier riding along the footpath if the cycle courier was an employee, and it was thereby vicariously liable for negligence of the cyclist in the course of the cyclist's employment. And most of the case in the lower course was actually about whether vicarious liability should be expanded to cover contractors, or at least some contractors. And Varbu approached the question of, and this perhaps demonstrates the uncertainty of the law in this area, it approached the question of employment with some confidence because it had won a payroll tax case some years earlier in the New South Wales Court of Appeal about its couriers operating under the same system, albeit in that case a guy who was driving a car and delivering parcels rather than riding a bicycle. But nonetheless, it thought, well, look, we've set up this system, it got through the New South Wales Court of Appeal, so we should win. They didn't win, though. They lost ultimately in the High Court, which thought it knew better, and I suppose it always does. And it's instructive because it looked through the various factors that were relevant, and they included whether the couriers were in any sense really running their own business. And they said it just doesn't make sense to say that. They're wearing the uniform, they only take direction, they only do delivery jobs for Varbu. They couldn't develop any goodwill in it. It's not like they could go out as a freelance courier. They only get jobs through the company. They had little control over the manner of their work and were directed as to when they had to turn up and what they had to do. They weren't permitted to delegate. They were required to wear a uniform and presented as emanations of Varbu to the public, and were told they were supposed to be polite and well behaved and the like. And Varbu controlled what they were paid, and they were, they were not able to bargain with the person who needed a parcel moved to get a better rate. It was all determined through the company. Now, it doesn't take too much imagination to apply that kind of reasoning to food delivery on bicycles, or indeed to... Uber is a little different because taxis have a quite different history of regulation in this regard, but it doesn't take too much difficulty to endeavour to apply that reasoning, particularly to any kind of delivery work, at least where the amount of the sort of equipment invested in is not great, no greater than a bicycle. And almost inevitably in those businesses, the worker is going to have to be directed as to when to turn up. They are going to be reliant entirely upon the company for the provision of work, that is to be allocated jobs, and for the earning of their income. And it's very difficult to say that a person riding around on a bike with Deliveroo written on the back of it in big lettering is running their own business in any sense. They're not separately going to restaurants and saying, I can give you a better deal to deliver your meals. It all operates through the established system that the company's operating. Yes?
Yep. Let's ask, with that case, did each person that rode a bike, did they sign an individual contract or an agreement with the company stipulating what the arrangement was, or did they just come in and have been told?
Yep, they signed contracts, and the contracts said they were independent contractors. The court thought, well, it did say that, but when you look at the truth of the matter is that they were not, when one looked at particularly the control that was exercised and whether or not really they could in any reasonable sense be said to be running their own business. The provision of equipment, that is whether you provide some relatively substantial equipment or is a significant factor. The court there didn't think that a bike was a significant investment and did note that it's capable of being used for other purposes as well, so might not have even been specifically bought for the business indeed. I suppose the same could be said of a car really, but at least in Uber's case. So as I said, there was a contract and it did say that they were engaged as independent contractors.
If you were looking at the control and that wasn't sort of obvious, could you look at factors like the regularity of the shifts, the most common place of work? Yep. Regularity of hours or the capacity of the worker to determine when they work or where they work, rather than just being told when and where they have to turn up. Is all relevant to the degree of control. And look, these businesses, self-evidently Choristers Couriers wanted to set up an arrangement where its couriers were independent contractors. It wrote it in the contract and it had set up its business in that way. But having said that, the essential nature of business is it needs the packages to be delivered in a timely and efficient way. So it can't just have people who don't turn up, or it has to, as a practical matter of operating its business, have people who turn up at the right time, make the deliveries within the time that's specified, and don't turn deliveries down or don't say, oh no, I'm busy now, I'm doing a delivery for someone else. They do need people who work solely for them and in an efficient and timely way, as do no doubt all of these other businesses. Now, the sort of Uber, Deliveroo, Foodora type businesses, there is certainly contemplation of litigation in Australia in this area. There has been litigation, particularly in relation to Uber overseas. There was a big class action in California, which got through being struck out at least by Uber. I've read that there's a proposed settlement of $100 million or something for the drivers. There seemed to be protested by some of the drivers about the settlement and that the lawyers were taking all the money and like, which does happen. I don't think it's been approved by the court as yet, at least as I read it. There was a case, though, that went to a decision in the Employment Tribunal in London called Aslam and Uber. There's a couple of things to note about, just by way of introduction. It concerned whether or not Uber drivers were entitled to benefits under legislation called the Employment Rights Act, which is the main industrial or employment legislation in the UK. It's a bit different over there than it is here, but there's two things to note about it. One is this decision is subject to appeal, so it won't change, I suppose. The second is that the legislation has a slightly broader definition of what a worker is. So there's a definition of a worker which includes an employee, but has a somewhat extended definition that includes a person engaged under a contract for their labour, where they are doing work for an entity that could not be described as a customer or client of that person. So, I mean, if you get a plumber to your house to
fix your pipes, you're not engaged. You're their customer, I suppose. You're not engaging them as your worker. But if the plumber works for a plumbing company, I suppose they are not a client of the plumbing company is not their client. They are doing work for the company.
Can I ask a question here? What about Airtasker?
Airtask?
Airtasker, that is.
I don't know Airtask. How does it work?
Well, you lodge a requirement to do some work or a job or whatever, and you get bids, and then you accept.
Oh, okay. Yeah, no, I've heard of this. Yes.
And
Someone's
it can
proposing
be
barristers
IT,
should do this, but
it can be cleaning house, washing windows, it can be any full range of services.
yeah, I mean that's probably more difficult in the sense. Well, Uber tries to portray themselves as if they are like that. Actually, that is, they are connecting customers with people who want to drive them places, rather than conducting their own business. If the consequence of that platform, as it were, is that an individual does car washing or whatever, window washing, and they end up doing work for one person one day, a different person the next day, the next week enough, it's difficult to say who they were employed by, and they probably aren't employed by an entity which just simply runs a website which facilitates that occurring. It's difficult in the sense that the website doesn't run a window cleaning business. It might be different if there was a window cleaning business which advertises itself and facilitates and then has lots of people who it purports to engage as contractors to do that work. That might be different. But if the only function of the website is really to connect people who want a task done with people who do it, then it's probably more difficult. Sorry, back to the Employment Tribunal in London. As I say, the question concerned the application of this employment rights legislation in the UK to Uber drivers. And it is a bit different to Australia, so you can't just say it's exactly the same because of the way in which that legislation was structured. But the decision is useful. The Employment Tribunal, it's quite entertaining if you like this kind of thing. It's quite an entertaining decision, but it didn't have too much difficulty calling out bullshit for bullshit. When one looked at the way Uber described its business. So it said, among other things, it seems to us that the respondent that Uber's general case and its written terms on which they rely do not correspond with practical reality. The notion that Uber in London is a mosaic of 30,000 small businesses linked by a common platform is, to our minds, faintly ridiculous. In each case, the business, in inverted commas, consists of a man driving with a car seeking to make a living by driving it. The absurdity goes even further. Actually, the contracts deny that Uber is engaged in transportation business at all. As I said, for a company whose sole business is facilitating one person being moved from where they are to where they want to be, to, as a matter of contract, require its drivers and customers to agree, as a matter of contract, that it doesn't provide transportation services, requires a degree of scepticism.
Just get the public to testify.
Indeed. As they also noted, and I think appropriately, again, the terms on which Uber rely do not correspond with the reality of the relationship, and that the problem stems, in part at least, from the unequal bargaining position of the parties, that many of the drivers, who frequently were not English speakers as their first language, were not accustomed to or in a position to deal with the contractual documents. The contracts seem quite hilarious, really. I mean, the court did, or the tribunal, sorry, did comment upon that they invented their own language. That apparently onboarding is used for induction or becoming engaged is onboarding, and dismissal is
waterboarding.
So, as I say, the court, the tribunal, looked through the reality, and it was clear that the drivers are working for Uber, not running their own businesses. The driver doesn't have any negotiation with the passenger about where they're going to go or what they're going to be charged. All of that is determined by the use of the app or the website before the driver even knows where the driver's going or who they're picking up. And I don't use Uber, but apparently the driver doesn't know where they're taking you until they get to pick you up. So the concept that they're running some independent business is as the tribunal said, faintly ridiculous. Now, whether the same conclusion would be arrived at in Australia is a matter which will await litigation, no doubt. As I say, as I understand it, Uber has appealed this decision in the UK, and I'm sure perceives it as an existential threat to its existence, or at least the business model that it's chosen to operate under. As I say, I know that people are contemplating litigation in this area in Australia. One of the difficulties will be that no doubt it will be substantial litigation and very strongly fought on the other side. But one of the other difficulties is finding individuals who are able or willing to participate in such litigation. Frequently the people who are doing work of this nature will be transient or otherwise non-unionised or for various reasons unlikely to be in a position to readily obtain legal advice or readily complain to authorities about the conditions of their engagement. And I mean, it may be that community legal centres are more likely to see clients of this type than traditional law firms. But there is certainly potential for litigation directed at whether there's a breach of the sham contracting provisions, whether there's underpayments of wages or penalty rates or overtime, which there most likely will be, or other breaches of hours of work requirements and the like. As I say, such litigation is likely to be quite ferociously fought, I imagine, but there will be cases, no doubt, going forward. Now, if a person is properly found to be an independent contractor, I don't want to suggest that they have no rights at all. That person will, of course, not have the rights that all employees possess to minimum wages and hours of work requirements, leave and the like. But there are some protections. Firstly, they have the rights that exist under their own contract, so that's the first thing to look at. That is the contracts, although some very one-sided in this area, they do at least provide an entitlement to be paid for the work performed at the rate contained within the contract. So if for some reason or other that's not done, there is a remedy for a failure to comply with the contract itself. There are other particular provisions which are nonetheless applicable to independent contractors. There is a piece of legislation called the Independent Contractors Act, which allows a court to review an independent contract or a contract for a services contract, as it's called in the legislation, on the grounds that it's unfair or harsh. It's not much used legislation, to be honest, for various reasons. But there have been some cases, some about IT workers and the like, historically about truck drivers as well. The court is able to make, as I say, a very broad finding about the fairness or otherwise of the contract under which the work is performed, and that would include consideration of the relevant the relative bargaining power of the parties to the contract, whether the contract protects the worker from arbitrary termination of the arrangement or from just being deprived of work at any point in time, whether the contract is such as to provide remuneration less than would be earned by an employee if they were doing similar work, are all relevant considerations in an assessment of the fairness or otherwise of the contract. And the court's able to vary the contract in order to make it fair, and although there was some debate about it for a while, also vary the contract to provide for a payment of an amount of money by way of compensation if that's what the court considers to be the appropriate course. As I say, it's not been a much used vehicle, but it's an available option. The other is there are general protections provisions in what are called general protections or adverse action provisions in the Fair Work Act, which apply to employees but also apply more generally. For those who are not familiar with it, those provisions, which are proving problematic in their application, but nonetheless, they do, in theory at least, provide protections against what's called adverse action, which can be termination of the arrangement, but can be other things as well, deprivation of any benefit or depriving of overtime or demotion or anything of that nature. They prohibit adverse action, as I say, being taken against a person for various reasons. So it's like discrimination legislation. It turns upon the reason why an action was taken, and if the reason why an action was taken was a prescribed reason, then there'll be a contravention of these provisions. They include because the person's exercised a workplace right, so that can include having an entitlement under an award or an industrial instrument, making a complaint, bringing proceedings or the like. Because they're a member of a union or not a member of a union, because they engage in industrial activities. There's various discriminatory grounds, race, sex, sexual orientation, etc., family responsibilities, marital status, temporary absence from work for illness or injury, or because they are or are not covered by a particular award or enterprise agreement or other industrial instruments. As I say, those provisions apply to employees. Most of the cases are about employees in this area. There's a whole other, I could do another talk about that, but the definition of adverse action extends though to contractors as well. So a principal of an independent contractor commits adverse action if they terminate the contract, injure the contractor in the terms and conditions, alter the position to the prejudice, or refuse to make use of the services of the independent contractor. So if you have a contractor who's made a complaint to a regulatory agency or the like, and they're terminated as a consequence of that, then there's a potential breach of the general protections provisions in the Fair Work Act if that were to occur. The difficulty that's been encountered with these cases is that it all hinges on why something was done. If someone from the company comes along and they wear a suit and they say with a straight face that it had nothing to do with the person's race, sex or sexual orientation or the like, or because they were the member of the union, and you don't have some smoking gun that proves otherwise, then you lose the case, which has been the recent record in most of these cases, to be honest. But nonetheless, it is, as I say, an extension, a protection that is extended to independent contractors. And it may be that companies that are dealing with contractors think they can get away with these things a bit more, so it might be a bit more slapdash about telling the person that because they made a complaint that they are to be terminated. Whereas employers are at least wise to the fact they have to think of some other reason that has some degree of vague plausibility about it. All right, the final thing I was going to say, and this was the other thing that I was asked to talk about, and that was the kind of 7-Eleven examples as well, or trolley collectors, I suppose, is the other, where there's franchising or subcontracting type arrangements which are utilised, which sometimes through some sort of complex contracting chain lead to a worker at the bottom of the heap who isn't paid in the manner that they are required to be under an award or the legislation. In a sense, this, perhaps unlike Uber and Deliveroo and the like, doesn't present anything particularly new. This is just old-fashioned exploiting people and not paying them their entitlements. There's not some sort of quite legal strategy involved in this. It's just underpaying individuals. The 7-Eleven cases, no doubt you have some familiarity with. That turns out, I don't think it's controversial now, there was large-scale underpayment of individuals who worked in 7-Eleven by franchisees of 7-Eleven, which at least the head office had some knowledge of, or at least was part of a deliberate business strategy in some respects. As I say, that's really just old-fashioned not paying people what they're entitled to. I think what those examples did demonstrate is the difficulty, leaving aside legal entitlement, of enforcement and compliance, of ensuring enforcement and compliance, particularly when you have workers who are often quite vulnerable to other pressures, and grateful to have the work that they have. I suppose there's two things about those cases that warrant mention. The first is that I think they did reveal the extent to which, or the extent of the efforts to which some businesses will go to disguise the failure to pay individuals properly or otherwise comply with employment obligations. The common strategies were, and this was particularly where people were on student visas or the like, was recording the person's hours as 20 hours a week, which was the number of hours that they were permitted to work under their visa, but in fact, and paying them the amount for 20 hours, but in fact they were working 30 or 40 hours in the week. Requiring employees to pay back money in cash by some kind of duress or threat. So having been paid the correct amount into their bank account, in order for it to look like they were being paid correctly, the person was, by some form of threat, compelled to give money back in cash to the business. Also overcharging for accommodation or at the back or above the shop or something of that nature was also came up in some of the instances where they'd be paid the wage, but then out of the wage would be deducted some amount for accommodation or board or the like of an excessive amount. And the difficulty of investigating those cases, I mean, in the 7-Eleven case it became sufficiently notorious that the Fair Work Ombudsman became involved and did some kind of investigation, and Four Corners became involved too, so at least there was other people looking into it. The second feature of those cases, though, and I think this is also common in the kind of trolley collections at supermarkets and the like as well, is, and is in transport as well, is that really that systematic change in those areas to address the underpayment problems really can only happen where the entity that is ultimately benefiting from the whole arrangement, 7-Eleven in its case, is in some way made responsible for any failures by entities further down the chain. So 7-Eleven doesn't operate in stores, it enters the franchise agreements with franchisees who then underpay the staff, and 7-Eleven, and there was in the Fair Work Ombudsman report, there is correspondence and the like set out where a complaint would be made to the head office and 7-Eleven would write back to the person and say, oh, we've made an inquiry with the franchisee, but they refuse to answer our questions, so there's nothing we can do about it, we don't employ you, kind of thing. And there's criticism of the supermarket chains in the same area, particularly in the transport area, but also in the trolley collections. So the Fair Work Ombudsman did commence a case against Coles in relation to trolley collectors who were being underpaid. Again, Coles wasn't directly employing the trolley collectors. They were engaging another company, which engaged another company, which engaged another company, and which ultimately employed individuals to collect trolleys in the supermarket car park. And they ended up not being paid correctly, surprise, surprise. And Coles was ultimately able to settle that litigation on the basis that it entered into what they call an enforceable undertaking, so it would undertake to fix things up going forward, in short. And I think it did actually decide to in-house some of that work, at least, that is directly employ people to do that work. And it undertook to monitor some of the contractors that had continued to engage in order to ensure that they were paying people correctly, or so it says. But unless there's some mechanism of making sure that the business that actually benefits from these arrangements takes responsibility for ensuring that the law is complied with. The mechanism that was used to pursue Coles was a provision of the Act which extends liability to people who are involved in contraventions. So to take minimum wages as the easiest example, it's actually only the employer of an employee that's required to pay the minimum wages, no one else. But if that doesn't happen, there's a contravention of the Act. If another person is involved in the sense that they aid or abet or induce or are knowingly, directly or indirectly knowingly concerned in or party to the contravention, then they can be taken to contravene the provision.
Was that the case in the 7-Eleven instance? Did they hit the franchisee?
Franchisor. Yes. I don't think it's progressed to that level yet. There's been a settlement of an action against 7-Eleven in which it agreed to pay a sum of money. But yeah, it could only be involved in litigation directly by the use of this kind of mechanism. It was not directly the employer of the persons who work in the stores. They were employed by the franchisees. But if it had sufficient knowledge, and these are hurdles to get over, but if it had sufficient knowledge, then it could be taken to have contravened the provision, even though it wasn't directly the employer of the workers involved. And as I say, this was the mechanism that was used to drag Coles in. So the litigation was against the companies that employed the trolley collectors, but they joined Coles as a respondent on the basis that it was involved because... And look, I know the large supermarket chains, they price everything out. They know how much everything costs with their suppliers, with their transport. They know how much it all costs. So if they are paying under a contract X dollars for a trolley collection service, they will have priced out how much it costs to employ all the people to do that work and won't pay a cent more. But if they're paying a lot less than they know it would cost to actually employ the people and pay them according to their legal entitlements, then they would be knowingly concerned. Now, establishing that in litigation is obviously difficult, but I think one can be reasonably confident they know how much they pay under their contracts and whether or not it is justified by the costs that are incurred. But that is a mechanism that can try and drag in the entities, as I say, that actually benefit from the whole business arrangement in the first place. But as I say, there's nothing particularly new in these examples. They're really just old-fashioned, not paying people their lawful entitlements.
Is that provision Fair Work Act?
Yeah.
And would that be possible to use that provision in where you've got like labour hire contracts and other types of things like clerical services?
Yeah.
They terminate the contract with the agency and the person loses their job, but they don't have unfair dismissal or...
Yeah, well, that's a more difficult situation because this provision, the effect of it is that a person is taken to have contravened a provision if they're involved in a contravention committed by another person. The difficulty with that example is there may not be any contravention of by anyone, in the sense that look, labour hire is used, as are contracting arrangements, as a mechanism to avoid entitlements. They are also a useful mechanism of allowing greater flexibility in up and downsizing workforces. That is, if the people can be got rid of without the entanglements that might otherwise ensue from having an employee. So if a workforce is engaged through a labour hire agency and they want to get rid of someone in particular, they can just write to the labour hire agency and say, we don't want that person anymore. And the labour hire agency says, well, we don't have any work for you anymore, so we didn't do anything, it wasn't our decision. And the company says, well, you're not our employee, so there's nothing you can do about it. Now, there have been a couple of cases recently about that situation. The current state of it, I think it's still up in the federal court now, but the full bench of the Fair Work Commission found that the labour hire agency, so it was a BHP case actually, so a worker who was working on the docks actually was... BHP said, we don't want this person here for a particular reason. There was a conduct issue and said, we don't want this person here. And then the labour hire agency said, well, you're sacked because we don't have any work for you, not because we think you did anything wrong, but because we don't have any work for you. The full bench of the Fair Work Commission found that there was a valid reason for the labour hire company to terminate the person because, in relation to his capacity, because he didn't have the capacity to do the work that he was employed to do because BHP didn't want him there anymore, in short. So there's different factual scenarios that could arise, but it's a difficult situation, that one, legally. All right, that was what I was going to say. I'm happy to answer any questions if anyone else has any further questions. Otherwise, I hope it was... Yeah, sorry, there's another one. Yep.
Just think of a scenario where a employee the company set up another entity seen those arrangements or have you been
Yeah, that happens quite a lot. I mean, that's what happened with the Patrick's Wolf dispute. They set up there was a somewhat more concocted plan, but they transferred the workforce to a company which didn't do anything else other than to supply labour to the Patrick's Wharf, and then they terminated the labour supply arrangement with that company in order to jettison the workforce they didn't want anymore. That the company that was nominally the legal employer didn't have any other didn't have any assets, and it didn't have any other operations other than just employing these people for the purpose of supplying them to the other Patrick's company that actually operated the wharf. And it's actually quite common for whole workforces to be engaged by a labour hire agency, whether it be a third party, an external body, or simply an associated entity. If it's just another company within a company group, and there's a company that's the employment company and a company that does the operations, it's not as straightforward for the company just to terminate the arrangements between if the individuals were made redundant in that situation. There is a capacity to reinstate to a related entity, so that there is some capacity for something to be done about that. The arrangements can also just fail, that is, fail to in fact establish an employment relationship with the other company, because what often happens is, and I think I've seen cases in mines, so the mine has there was a factory case too, I think. The mine has a job available, and so it advertises for a job. The person goes to the mine, has an interview with the manager, is told all about the job, asked what their experience is, and told, yes, that's great, you're perfect for us, we want you on board, can you just go down to this office down the road and sign up these papers with this completely separate company that doesn't operate in the mine. That can fail. It can be found that in truth what happened was the person was employed by the mine because they went to the interview, they were told about the job, they were told what the rate of pay was going to be, and the formal legal documents don't evade the practical reality of what really happened there. So the arrangements can fail in a legal sense as well.
All right. Well, if there's no further questions for now, could please speak, Mark, for a fabulous talk.